of Law and the Center for Criminology in particular for inviting me as a part of the Also seminar series. It's a great honor and also slightly daunting, I have to say, to be part of this series and especially to be within the walls of this distinguished institution. And I would like to express my most sincere gratitude to Professor Mary Bosworth for personally extending the invitation, but also for being an inspiration and a trailblazer in the field of border criminologies. And about border criminologies, I think it's important to note that a special congratulations are in order, as this year marks the 10th anniversary of the 10-year anniversary of the Border Criminologies Network, which is, for those of you who might not know, maybe those online, the interdisciplinary network that was started by Professor Bosworth and her team, and which has developed into one of the key sources for critical and up-to-date information on a broad variety of issues related to migration and borders. And so I'm going to take you down to a slight, or down a trip on memory lane, because I remembered, or I realized while preparing for today, that 5 years ago I was also saying something during another anniversary of the Border Criminologies Network, hello, which was the 5th year anniversary. And it was a sunny day, I remember, in Oxford. And while preparing for that talk, which also was difficult because, as you probably are very well aware of, talking about borders and migration, writing about it is not the most happy of topics. I remember back then finding inspiration in Emily Dickinson's famous poem, "Hope is the Thing with Feathers." And so let's see if this works. And so while thinking about today's talk, for some reason, that beautiful little simple poem, and take some time to read it, I'll move away from the screen, it just fluttered back into my mind. And I don't know why, maybe to remind me of how important it is to remain hopeful or to be hopeful, or perhaps to reflect upon the possibilities of even remaining hopeful in a world that seems to have turned significantly more darker or a little bit more grim, so to speak, since the last time I was speaking here, so over the past 5 years. Whatever it is, like in any case, while thinking about the significance of this synchronicity, in my inspiration for today, I also chose to draw again from that beautiful little poem that you can see and read behind me. And yeah, I hope that you have been able to read it like over me or along me. It's or if you're all familiar with it, it's a beautiful little poem. And so I went back to also think about and look at moments in time within the field of criminology where different people felt the need to speak out or to speak up about situations or developments that they found problematic or daunting, and they saw the necessity to call for action to the larger field of criminology. And I stumbled upon, or I found, the 2014 presidential address by Joanne Belknap, who at the time was the president of the American Society for Criminology. And in this address, she refers to, at the time, and I would say still ongoing, quite dire situation in the US criminal justice system. And she called in 2014 on criminologists to be more active and more activist in addressing harmful and unjust patterns visible in and created by the system. And so she states, and I'll quote her, "If criminologists are unwilling to become more committed to activism and dedicated to changing these practices and policies, we can expect continuing and alarming ineffectiveness in deterring offending and incarceration. Indeed, we can expect a backfiring of our stated efforts, and in short, we are falling down on the job." While looking at the situation around migration and mobility in Europe, at the atrocities that are happening at Europe's external borders, in detention centers, at the overall racialization of mobility within Europe, the normalization of exceptional measures, and the rise of neo-nationalist parties beating the drum of Islamophobia, anti-immigration in the name of national security, national identity, I think a similar call can and should be made. Yet, I would add to this call the necessity for criminologists and lawyers to collaborate in identifying, questioning, and challenging the rise of what Katja Franco has termed abnormal justice in response to the mobility of people. And of course, there's a reason why I'm calling for the joining of forces even more than is already happening between criminologists and lawyers, because I have a background in law myself, and I'll talk a little bit more, or actually quite a lot a bit about that in the continuation of this talk. But I'll also argue, or hopefully explain, why I do think that we could even further tighten these connections in the name of being more activist or being more public criminologist. The necessity, right, to identify, question, and challenge the rise of this abnormal justice system is connected to the necessity to also, as has been vocalized amongst other people by Vanessa Barker, to, quote, bring the state back into our research and debates that we have amongst each other, and debates that we have with the public at large, as it will be impossible to get to grips with the historical importance of today's mobility and mobility controls if the role of the state and its purpose, its institutions, its actors, and its interests aren't thought through. And when looking at the developments around migration and mobility, and especially the control thereof in Europe, I think there has never been a greater urgency for legal scholars and criminologists to join forces. I will highlight the urgency of the matter by illustrating through a social legal analysis of the workings of what I have tentatively called the Crimmigration control apparatus as it operates within the intra-Schengen borderlands of Europe. And this is indeed something that I'm working on as part of a larger book project that hopefully will be done sometime this summer. But it's been really useful and really helpful, at least in preparation for this talk, and hopefully also based on the conversation that we'll have afterwards, to think through some of the parts of the book that I was finding myself being a little bit stuck. And so when we look at this Crimmigration control apparatus, and I'll go more into the terminology in a bit, in more Foucauldian terms, this should be seen, or an apparatus as such, should be seen as a device whose purpose is population control and economic management through a combination of different, otherwise scattered elements, discourses, architectural arrangements, but also laws, scientific statements, and so on. It is a strategic assemblage that is open to unforeseen and unpredictable events, and composed of a grouping of heterogeneous elements, and can be deployed for specific purposes at a particular historical conjuncture. And this is a quote by Rabanov. The historical conjuncture that was the creation of one European internal market through the implementation of the 1999 Schengen Agreement, through the Amsterdam Treaty, definitely led to the grouping of a broad variety of elements on European, but also on member state level, that were geared towards the management of the mobility of this, what I will explain to be rather paradoxical space, in which the economic benefits of the free movement of goods, services, and people had to be balanced against a perceived national security risks of this same free movement. And this is what is often referred to as the paradox of the migration state. I will argue that only through great systemic changes from within, we might be able to take an exit from what I also tentatively call the road to dystopia. And that in order to do so, we need to identify key crimmigrators. So those actors whose decisions play a crucial role in driving, creating, and maintaining this control apparatus. Mind you, I am by nature a very optimistic person. I like to think so. Might appear quite contrary up until now, but I will always try to look for, for maybe what Emily Dickinson would refer to as that little thing with feathers. So I'm always looking for something to be hopeful about. And I will explain this in more detail, I found that hope, maybe strangely so, through studying the crimmigration control apparatus from within. So I will end my talk with a reflection on some of my own experiences of researching this apparatus from an inside vantage point. And related to that, I will share some reflections of what it means to me personally to be an activist criminologist, or maybe, you know, maybe I'm not, or but at least how I like to sort of define that term for myself. But I will also add a couple of words of caution to ensure that maybe in getting lost in how we define ourselves and how we define others through some of the choices that they make, that we do not abash that little bird of hope. So that's sort of what I have planned for today. I have 7 slides, so it's a lot of talking and not a lot of slides. But yeah, feel free in between, if you have questions about unclarities, to already ask a question in between. So over the past almost 2 decades, scholarship addressing and also questioning more so the notion of what has been called crimmigration has flourished tremendously. And looking at immigration and border control through the sensitizing lens of crimmigration allows for a better understanding of how certain processes, how certain state processes take place. The notion of crimmigration sort of urges us to focus on developments that to an outsider might not necessarily be strange or problematic, such as, for instance, attributions of powers that are parallel to policing powers in the criminal law system to immigration officials, which is obviously a different area of law, but also through the use of criminal enforcement tools in the immigration system, which has a great impact on particular detention and deportation practices. Furthermore, these developments in which the immigration system and its actors are more and more operating as if they were part of the criminal justice system, and whereas criminal justice actors get to exercise powers in the immigration realm, have not been accompanied by a greater procedural protection for those who are subjected to these crimmigration practices. And this is obviously a problem, especially when you place what is happening within the larger context of the criminalization of migration and mobility. So much of the study of crimmigration is devoted to what powers are wielded when crimmigration is in play, where those powers derived from historically and doctrinally, and the theoretical and functional implications of this phenomenon. These are all important questions to ask, and I think various valuable contributions of crimmigration scholars or scholars focusing on the phenomena as such highlight a critical but understudied question that bears on whether crimmigration is amplified or deflated, and whether there are differences between different regions in the world. And these are questions that are now also beginning to be researched. So myself, over the past couple of years, I've grown more interested in not just understanding what crimmigration is and how it is visible in different more European cases, because most of my work has been focusing on the Netherlands, but also other European countries. But maybe also in the light of being a person who likes to be hopeful, I figured, well, you know, I can continue sort of tracing this process and seeing like how bad things are and how terrible everything is on a more procedural or formal level. But maybe I can find a way in which I can think about how we can subvert or change this process. So over the years, I've grown more interested in the question, who wields crimmigration power? And it was interesting, last summer we had the annual conference for the Law and Society Association in Lisbon. And together with Juliet Stumpf, who is the person who coined the term crimmigration, we got to talk about finding out who the actual crimmigrators are. And that's actually been a question that has been sort of on my mind for the past couple of years. Now, we'll explain to you in a couple of minutes where that comes from. So I've been grown interested in sort of identifying who are the crimmigrators. And I think that it is critical to understand how the decision to create a crimmigrator, but also that, you know, knowing where these powers are located, how that can affect the outcome of some of the decisions that can have a detrimental effect on the lives of people who are subjected to these crimmigration powers. And so this question, who are the crimmigrators? And for me, that question has sort of turned into the question, who is the key crimmigrator, right? You see, I'm looking for a main culprit here in the story of intra-Schengen border controls. But this question also arose from my initial entry into studying what I call, and I will explain to you in a second what it is, these intra-Schengen borderlands, which is through studying immigration checks that were carried out by the Dutch military and border police. I know, and I always have to say that because the official translation of the Dutch organization that I am now referring to as the Military and Border Police is actually not the Military and Border Police. They want to be referred to in English as the Royal Netherlands Marechaussee, which is an awful word to say a lot in a talk. So I'm just going to say it now. This is what their official name is. We are going to refer to them as the Military and Border Police because it's basically the same. It's a matter of terminology. But yeah, so I entered into this area, maybe even into the field of studying what happens in borderlands through a particular interest, mostly in a law enforcement organization. And I'm more than happy to talk about like where that came from if people are interested in it. During the Q&A, I write quite a bit about that also in the book, because I think it's always interesting to sort of understand where people came from, how they entered into a field and into a research area, because it can explain like some of the choices that you make or some of the questions that you ask. So for me, entering into this space that I will identify in a second, through working with or having the opportunity to study this organization, is how I arrived in this particular field of studies. And I'm using the word intra-Schengen borderlands to make clear that I'm not talking about checks that are carried out at the actual physical borders between two Schengen member states, but to the checks performed in the area around where the physical border is. In this area, according to the Schengen Borders Code, which is the body of law that sort of governs what countries are doing in order to make sure that they act in line with the Schengen Agreement. But in these areas, so not at the physical border, but around the physical border, countries are allowed to organize migration controls, as long as these controls in practice do not have the effect of permanent border checks. And the latter would obviously be problematic in terms of the right to free movement that is central to the Schengen Agreement. And how big or what the size of these borderlands are in terms of square kilometers is actually very hard to say, which already touches upon the importance of the notion of discretion in understanding the intra-Schengen crimmigration control apparatus. I think that's a lovely word or sequence of words, because there's a great difference between countries. Whereas in the Netherlands, the borderlands mean it's an area of 20 kilometers around the border, land inwards, obviously, because these checks can only be conducted on incoming persons and traffic. Germany chooses 30 kilometers. In Poland, there seems to be a little bit of ambivalence depending on where you are. As some parts of the border, it's 30 kilometers. Some say 40. Some of them say, is there supposed to be a stop to where we conduct these checks? And so on and so forth. So there's a lot of discrepancy within Europe, actually, where these moving borders are. And so to be clear, the policing activities that I studied are carried out under Article 23 of the Schengen Borders Code and are thus not to be confused with what also happened a lot, not just in response to COVID, but also in response to the 2015 large movements of people, but also something that is sort of called upon when there are big political events, which is the temporarily reintroduction of permanent border checks. That can also happen, but that happens under Articles 25 and 29 of this same code. And that basically means that there will be people at the border, at the physical line between two countries, and every person and every car will be stopped. So the policing activities I studied extensively are always carried out, not just for a particular predefined period, and which illustrates how the Schengen Agreement as such should, other than what was often presented, not be explained as an agreement that made permanent border checks disappear, but rather as an agreement through which these border checks were reconstructed, repackaged, and relocated. Roving controls scattered out through spatially varying intra-Schengen borderlands replaced permanent border checks and made the border from a fixed line into an ever-shifting amorphous entity. An entity that does not become equally visible to or is equally experienced by everyone who, while enjoying their freedom of movement through and within this Schengen space, crosses the border, as these roving controls also work as a social sorting mechanism, sometimes supported by so-called smart technologies, but not necessarily. And so now that you hopefully have an idea of, and hopefully also an image of this setting, let me get back to the notion of the Crimmigrator, because that's what I promised to be talking about. So during my fieldwork with the Dutch military and border police, and the many hours of deep hanging with these agents or with these officials, it was clear to me, or it became clear to me very quickly, that they were Crimmigrators, a military police agency tasked with migration control, but also authorized to act as agents of crime control. So they literally have all the tools in their toolbox to pick and choose from, depending on their own assessment of a particular situation. Their decisions drawing racialized, ethnicized, and socially stratified lines. Yet, my fieldwork had also made clear that many of these agents felt trapped in a system that did not necessarily feel right. But the fact that their jobs were not just part of an organizational or national logic, but of a broader European logic. Most of my respondents found very little logic in this European logic, made them feel that questioning certain aspects of their jobs would be useless. I heard a lot of my respondents say, well, in the end, the reason why we're here in these borderlands, it is completely political. It doesn't really matter what we do, it's just politics. This is merely like symbolic, like this is a symbolic measure, etc. So this was a very common point that they addressed. And obviously, the fact that some of my respondents expressed feeling trapped and were very skeptical of the system within which they were fulfilling their role did not justify any of the problematic interactions and decisions I observed, but it did make me want to look beyond this one moment of discretionary decision-making in these borderlands and to understand their decisions through a more serial and holistic conception of intra-Schengen border policing, which looks to understand decisions in interaction with other decisions within the larger chain of decision-making that is often present, but that also would place their decisions within a larger historical and social political context. So that's what I do in the book. I'm not going to be able to talk about all that today, but I will talk you through part of that. So when one casts one's gaze beyond the most obvious, the most visible level, which is the street level, the answer to the question, who is the key Crimmigrator, actually quickly shifts, is what I found out. And I found that out on different levels, and I'll talk you through them one by one. So to start with the European legislature, and I promise it's not going to be a super technical legal talk, but it of course also illustrates one of the points that I started out with, the importance to also have a good understanding of the workings of the law when you're studying phenomena more empirically. So although the Article 23 checks that allow for policing activities in the intra-Schengen borderlands are conducted based on the same regulatory framework in different European countries, right? The Schengen Borders Code is the code that is applicable in any European member states. The checks can look completely different depending on where you are, whether you are in Germany, in France, in Belgium, the Netherlands, or in Poland. And the reason for that can be found in the legal workings of this code. The fact that the Schengen Borders Code is a regulation means that it applies automatically and uniformly to all EU countries without needing to be transposed into national law. Nevertheless, this doesn't mean that countries cannot choose to also develop national legislation with the aim to further specify the European regulation. This is an important observation, as this practice contributes to a great level of unclarity and legal uncertainty on the part of those who are making their way through the Schengen area in terms of what to expect when entering into these different border regions or borderlands, if it is already clear where such a space begins and ends. As I said, that also is something that is very much left to the discretion of national law enforcement agencies and national legislatures to define. Furthermore, it also allows for slightly different interpretations on the national level of the article itself, which, when you take a look at Article 23 and more closely, is formulated in a very open way, leaving a lot of room for discretion. Police checks, and I'm quoting the article right now as it exists in its current form still, police checks in the internal border areas are permitted as long as the checks do not have border control as an objective, are based on general police information and experience regarding possible threats to public security, and aim in particular to combat cross-border crime, as long as the checks are not executed in a similar manner as checks on persons at external borders, and are carried out on the basis, and they have to be carried out on the basis of spot checks. Looking at this description, it is interesting to see that there is a strong emphasis on cross-border crime, and that this is already, in the wording of the code, connected to the mobility of people. This is no surprise at all, as the matter of security and maintaining a high level of control were major concerns in the drafting process of the Schengen Agreement and the Borders Code, which led to an identifiable shift in the process from security as a potential limitation ground to security as a condition of possibility of freedom of movement, which has taken place in the consolidation of the supranational legal framework. Hess and Kasparek also conclude that, and I quote, Schengen land can be seen as having certain aspects of securitization as its conditions of possibility. End of quote. In the most recent proposal, and this is a very concerning development, I would say, in the most recent proposal by the European Commission to amend the Schengen Borders Code, the Commission further embraces the very harmful narrative which assumes that people crossing borders irregularly are a threat to the EU that need to be addressed by increasing policing and curtailing safeguards. The amendment suggests that Article 23 will be changed to include that internal checks are carried out to, quote, combat irregular residence or stay linked to irregular migration. In an attempt to prevent too many countries from temporarily reintroducing permanent border checks, so really having 24/7 checks at the border, the Commission stresses the importance, or the European Commission stresses the importance of Article 23 checks as a valuable alternative. While that might in itself sound like a reasonable suggestion, a closer look at the ways in which these checks are organized and implemented on a national level paints a rather different picture. So we're now moving or shifting from the European sort of legislature to the national legislature. So when zooming in on the national level, I indeed found that there is really no uniformity in how the various member states use the particular Article 23. not just in terms of spatial demarcations, but basically in every other facet as well. Most countries are using existing powers to stop and search and to stop and ask for ID based on either criminal law or administrative law, and sometimes both. France uses specific counterterrorism powers to carry out these checks, and the Netherlands has translated the article into its own national legislation. In some countries, the checks are carried out by immigration agencies that are also equipped with police powers, whereas in other countries, the checks are carried out by the national police tapping into special migration powers. Only a few countries have either specific border guards, such as Poland, or, alike the Netherlands, make use of the military or military-like organizations. No matter the exact legal foundation on a national level, what all these checks have in common is that they are examples of crimmigration control in the intra-Schengen borderlands. Furthermore, the checks are all highly discretionary. Border officials, immigration agents, however they refer to themselves, enjoy a great amount of autonomous freedom in deciding on whether or not to stop and check someone. Primed by organizational targets, at times seemingly anecdotal intel, and as a great diversity of political and societal narratives on who are passing through these intra-Schengen borderlands, welfare scroungers, terrorists, crimmigants, vagabonds, carriers of disease, officials tasked with the execution of these checks in whatever form or shape develop a racialized, gendered, and socially stratified suspicious gaze. Research from the EU Fundamental Rights Agency in 2021 shows that people from an, and I quote, ethnic minority, Muslim, or not heterosexual are disproportionately affected by police stops, both when they are walking and when they're in a vehicle. And in addition, another study from the agency showed that 79% of surveyed border guards at airports rated ethnicity as a helpful indicator to identify people attempting to enter the country in an irregular manner before even speaking to them. The aforementioned proposed amendment to Article 23 of the Schengen Border Code that significantly broadens the existing scope of these checks by referring to the general, quote, exercise of public powers next to police powers, combined with the possibility of generalized monitoring and surveillance, including by technological means, only further raises concerns about the implications of profiling. And this is an interesting or an important thing to really, I think, sort of let sink in. Like, what does it mean, right? When the legislature all of a sudden includes not just exercising police powers or using police powers in a particular area, but also public powers, that immediately opens the possibility to any form of agency, not necessarily being like a police agency, to conduct very far-going coercive measures in these border areas. And the whole notion of profiling, despite there being like a convincing body of research, but also a lot of NGOs have asked attention for this, is not something that is addressed at all. So far for the legislature. So there's one level that I'm not necessarily touching upon in this talk right now, but I'm more than happy again to talk more about that in the Q&A. That's the level of the organization, because obviously what happens, like how these national norms are being translated into actual practices, there are two other important layers there as well, which is the level of the organization, right, that has certain goals, that has certain challenges in terms of having limited capacity, etc., but also the level of the individual, right, the individual border agent or the individual immigration officer. I did look into that as well, as I said, for the sake of sort of the coherence of today's talk. I'm not talking about it in the context of the lecture, but feel free if you have questions about that to write them down and to ask afterwards. Let's move to the judiciary, right? Because we focused on the legislature, we're now focusing on the judiciary. So the latter that I talked about, right, the implications of profiling and the possibility that these national legislations are also so vague that they could lead to racial profiling is something that is also like links me to talking a little bit more about the judiciary, because that might not be like courts. They might not come to mind immediately if you think about who can be crimmigrators. But as I will argue, or as I have found at least in analyzing this particular area of law and these particular checks, the courts actually do seem to play an important, maybe even also crucial role in maintaining the status quo. And when I say courts, I speak both of the courts on a national level as also about the Court of Justice for the EU. And so whereas national level judiciaries play an important role in checking and assessing the application and implementation of discretionary policing powers, the Court of Justice for the EU is sort of the European backstop to ensure that EU law is interpreted and applied the same in every EU country, and that EU institutions abide by EU law. As my research has shown, on both levels, the judiciary seem to contribute to maintaining the intra-Schengen crimmigration control apparatus, yet in slightly different ways, which I will explain. While the Court of Justice of the EU has repeatedly underlined the importance of the Schengen area as indeed an area without internal border controls, and it has also provided some guidance as to how countries should ensure that Article 23 checks in practice indeed do not have the same effect as if they were forms of permanent border control. When you look at the guidance, it leaves still a lot of room for discretion for the national legislature. And as the case Touring Tours und Travel, a case against Germany, illustrates, the national legislature and agencies tasked with the policing of the inter-Schengen borderlands will continue to explore the boundaries of the discretionary space that is left. This case that I just referred to, Touring Tours and Travel, shines light on the Article 23 practice in Germany, where national legislation required private coach operators, or private bus operators, to check passports and residence permits on cross-border services in the intra-Schengen area before boarding, and allowing for the imposition of fines on the coach operators in case of non-compliance. So every coach operator had to make sure that they checked everybody's passport, residence permit, paperwork before allowing them to go on a bus that would bring them across an intra-Schengen border. And of course, the question was like, is this allowed, right? What is happening here? So the court ruled that this practice was indeed a violation of the prohibition of border controls at internal borders, and that the fact that in this particular case, it was not the Bundespolizei who were conducting the checks on the documents, but private tour operators who do not possess powers conferred by national public law, did not matter. So they saw this as a breach, obviously, of the Schengen Agreement. As observed by German scholar Stiller, while reflecting on the impact of the Article 23 case law of the Court of Justice for the EU on the situation in Germany, but also in the larger Schengen area, the impact of the court, even though this was an important decision, but when you look at the impact, it's actually limited. In the light of the larger development of the crimmigration control apparatus within the Schengen area, the court also does not have sufficient powers to address the overall extension of various control measures as such. In order to do so, the court would actually need to overstep its mandate, under which it can only demand adherence to the current legal framework and only concerning the one measure or the couple of measures that are being presented before the court. So in other words, the court can never really sort of zoom out and say, well, hey, we're talking about this particular measure right now, which is problematic, but it's even more problematic if we place it into the larger development or the larger set of measures that we have within the Schengen area, right? It's very, like, for also understandable reasons, it's a very clear focus that they have to adhere to and that they have to apply. But keep that in mind, right? So on the one hand, we have the European Court that can only look very rigidly at this one measure, and the other thing is when they actually find that there is a breach of the Schengen agreement, or that countries are actually not implementing EU law the way it's supposed to be, there's not a lot that they can actually do, right? It's obviously a bad thing if you as a country create a reputation of constantly not adhering to EU law, but you're not going to get kicked out of the EU, right? So nothing really happens. That's all to say. That's not really giving off a great incentive to do better. But let's shift to the national court, right? Because we're looking at these different, the interplay of these different judiciaries. So we're shifting from the European Court of Justice to the less important, perhaps, but maybe as important, the District Court of The Hague. The International City of Justice, as it's always proudly referred to. I'm a bit skeptical about that, as you can obviously hear, and hopefully you will understand some of the skepticism in a second. So the discriminatory nature of the intra-Schengen checks recently has also been called into question in a national procedure where several NGOs, I think it was Amnesty International, Control-Alt-Delete, which is a national organization in the Netherlands, together with two people who had been checked at under Article 23, but in an airport. They together filed a claim against the Dutch military and border police for using ethnic profiling, that's the wording that was used, when conducting the Article 23 checks. And this was a case that was brought to court last year. And the appeal or the verdict of the Court of Appeals will happen on the 14th of this month. So there is an appeal, a little bit of a cliffhanger. So while indirectly following the logic of the US Supreme Court in the Brignoni-Ponce ruling, the District Court in The Hague argued that ethnicity, which in practice is actually used as a proxy for race, can be used. So it is allowed, the military and border police is allowed to use this to guide officers' decisions to stop someone and ask them for documentation, as long as the use of ethnicity is motivated and as long as it is part of a larger composed range of other indicators, such as behavior, status of a vehicle if they're crossing the border in a car, number of people traveling together, migration route, clothing, etc. And it can never be the only indicator that forms the foundation for the decision to stop someone. So as long as they adhere to all these criteria, then according to the District Court of The Hague, you cannot come to the conclusion that the Dutch military and border police is practicing ethnic profiling. The court found that in the context of immigration checks, someone's perceived ethnicity could be an objective indicator for someone's identity. Despite the proven strong presence of the Crimmigration stereotypes in the daily decision-making processes of the officers in the Dutch borderlands, combined with the observations of many scholars within and outside of the EU that have observed how racialized notions of suspicion seem to permeate migration and border control, the court saw no reason to prohibit ethnic profiling. So what do these reflections on the judiciary tell us? They show that in the larger context of this notion of crimmigration, as it operates within the Schengen area, the judiciary perhaps should also be held accountable, or at least should be questioned, for maintaining the status quo, both in terms of not really curbing the discretion on the national and implementation level, as well as in terms of actively acknowledging and taking action against these social sorting practices. Let me see where slide-wise. Perfect. So European intra-Schengen borderlands are places of, according to Gupta and Ferguson, incommensurable contradictions, where tensions between notions of openness and closeness, between security and insecurity, between freedom of movement and the restriction of mobility are all present at once. This is called the paradox of the Western migration state. This paradoxical foundation plays a crucial role in shaping the Schengen Agreement and the ways in which it is exercised in practice in, for instance, the inter-Schengen borderlands that are central to today's talk, but also obviously in other parts of the European Union, but other Western migration states as such. Tracing the roots of the Schengen Agreement, as has been done by historians, but also by scholars of international relations, political scientists, has clearly revealed how the agreement actually never intended to really give free movement to all whom are present within the Schengen space, but actually only to those whose movement were in some form or shape economically beneficial and non-threatening. And so realizing how the current crimmigration control apparatus fits in with, or better said perhaps is a product from political decisions and narratives that date back to the very first establishment of the Schengen area, steers towards a very grim conclusion actually. The system that, in the eyes and experiences of many, creates inhumane and racialized outcomes might be functioning exactly like it was intended to function. Given the fact that the Schengen Agreement, before it was incorporated in the European Union, was a multilateral agreement geared towards enhancing trade between the countries involved, makes it hard to pinpoint one key crimmigrator, because we're still after those crimmigrators, as the foundations for the system as we know it were fleshed out between the different original signatory countries. Whereas frontline border officials might be seen and experienced as the main crimmigrators since their discretionary practices are most detrimental to migrants in amplifying their vulnerable situation, I urge still to look beyond what is most visible to that what creates systemic crimmigration. Looking at the ever-growing interest in and emphasis on the use of Article 23 by member states in order to avoid the reintroduction of temporary border checks, as has been expressed by the European Commission, combined with the recent suggestion that directly criminalizes irregular stay and only seems to further enhance the possibility of racial profiling, in my opinion, the Commission seems to compete for the title of key crimmigrator. This is, of course, doesn't mean that the other actors that I identified, national legislatures, border officials, but also judiciaries, do not play crucial roles as well. But it does show that in order to really make a change, we might need to go back to the drawing board of the agreement itself. Understanding the movement of the inter-Schengen crimmigration control machine requires an understanding of the interplay and interaction between its different parts. Bordering practices cannot exist without a legal framework, which is as much a result of decisions made by the legislature as of decisions taken by the judiciary and all those in between. Understanding this framework and these decisions requires an understanding of the importance and power of strategically creating or maintaining discretion. And discretion can thus be seen as the ghost in the intra-Schengen crimmigration control apparatus that on the one hand keeps it together and allows for the development of a mobility regime built on what Shamir calls a paradigm of suspicion. And following, on the other hand, discretion within the apparatus necessitate looking beyond the most visible state agents, border officials, as the main crimmigrators, shows a more nuanced and perhaps even more daunting and concerning picture of supranational and national governing bodies deflecting responsibility for discriminatory and inhumane policy outcomes. In order to shine light on and fight social and legal injustice, which, according to Joanne Belknap, with whom's quote I started today's talk, it should be the main focus of activist criminologists. So if we want to shine light on and fight social and legal injustice, it is necessary for criminologists and legal scholars to work together. And I'm happy that this is something that I see happening and have seen happening all the time in the Border Criminology Network, where through interdisciplinary work, scholars have illustrated how in an increasingly complex social and also legal landscape, crime prevention schemes are inextricably linked to many legal arrangements, and how policing rules and coercive measures are regulated by civil law and administrative law provisions. This is the work that needs to be done. So this brings me, after this super depressing, what is it, like 35 minutes of my talk, brings me to the hopeful part of my talk. So I promised it, and here it comes, or at least I think it's more hopeful than what you've heard before. So as I just mentioned, Belknap defines an active criminologist as a criminologist engaging in social and or legal justice at the individual, organizational, and or policy levels, going beyond typical research, teaching, and service. For me, and this is becoming a little, or this is a more personal part, I think, of the talk. For me, this has meant putting myself as a researcher in uncomfortable situations, in the sense that I wanted to deeply dive into understanding, quote unquote, the state and its agents. Maybe this particular interest in the state comes from my legal background and the importance I felt of understanding the system before wanting to study it more empirically. Who knows? I think in general, I have always been interested in people, and especially those whose beliefs, choices, morals, or actions I don't really understand. It's also a good trait to have as a criminal trial judge, I have to say. That fascination is what actually drew me to criminal law and criminology, and that same fascination has also led me into predominantly studying the world of law enforcement. Over the past 10 years, I've spent hundreds of hours talking with border police officials, behind desks, in canteens, at parking lots, next to wet and windy, like Dutch roads in the middle of nowhere, in patrol cars, etc. I talked to border officials working on a more managerial and policy level, as well as to, and mostly actually, to border officials working in the borderlands that I've talked about so far on an operational level. And this research made me well aware of the fact that the depiction of border control systems as machines is as much useful as it can be problematic. Because the image of a machine, which is actually something that is often used to describe bureaucracies, paints too simple of a picture of the complexity of the human decisions, actions, and inactions that together form the machine. It also allows, or it sort of creates, the image of the state agent as being somewhat of a mindless drone who either consciously or unconsciously engages in coercive behavior. Neither states nor officials working in state agencies are rational apparatuses devoid of emotion and effect. And to borrow Brownlee's words, quote, such a deterministic approach ignores the reflexive agency of the human actor and the capacity for well-placed and charismatic individuals to influence the policy debate, notwithstanding the structural and cultural constraints of action. In his 2007 article, How Iron is the Iron Cage, Chaliotis calls attention to the fact that, despite working within the coercive contours of the criminal justice system, agents working within that system still have the agency to, in more or less subtle ways, resist the very system that they operate within by using or by potentially using the discretion that they have. Within the field of criminal justice, a field that, as you know, has been and continues to be characterized by an overall punitive turn, the latter might seem hard to believe. Yet, the author argues that through the use of their discretion, agents can, quote, oppose subordination to what may be seen as a mechanistic logics and practices of governmental power, end of quote. Although it is understandable that the very nature of bureaucracies obviates individual agency and makes it difficult to think of bureaucracies as sites of resistance, it is crucial to adopt a social notion of sovereignty that actually acknowledges the communicative process that lies at the heart of all social life and political action. As Bernstein and Metz note, a decisive event instigated by a willful individual does not simply set in motion an automatically applied rule. Rather, there is an ongoing linguistic and social process whereby exceptions are negotiated on the ground. It is simply not the case that some parts of the state decide while others merely carry out those decisions in a mechanical fashion. In other words, the fact that there is discretion within the system perhaps should not just be seen as something that can cause problems, but also as an opportunity, as a place for change. Nevertheless, when researching a political and securitized field, such as the field of intra-Schengen mobility management or migration control or borders at large, it can be difficult to see the state agencies and bureaucracies involved in the coercive and sometimes inhumane practices that constitute this control as something else than monolithic blocks where little individual agency, let alone resistance, seems to take place. Yet, as Guzzini argues, it is precisely in these fields where it is important to take a step back and to not fall into a benefit fallacy, in which it is assumed that individuals who benefit from a particular social system are deliberately maintaining that status quo. Quote, to say that a system benefits certain people does not mean that they cause that benefit or that they can control it. Why is all this relevant? Well, it is precisely the human part of the state that I have on numerous occasions struggled with during my research and actually felt very conflicted about. And while spending all this time in the back of cars, like along these windy roads, hanging out with border officials, I had, so many different conversations, like that had nothing to do with the work that they were doing, but were about their families, about relationship problems. Really, I solved many relationship problems during my field work, their upbringing, their education, their experiences during military missions abroad, right? Because this is a military organization, so people who actually perform these intra-Schengen checks can also have spent time in Mali or in Afghanistan. I talked about their views on the organization they were working for, their aspirations. They were often young guys, right, who didn't see themselves working within the same job until they were ready to retire. And during these conversations, a much more complex image of the state agent sort of arose. There was not such a thing as the agent as merely a wielder of force and a source of injustice. Nevertheless, when these same officers at other moments could engage in very racist commentaries or other problematic displays of power when interacting with people whose paperwork was being checked, it really created a schism in my mind. Because on the one hand, whereas these informal, more personal, and sometimes even intimate conversations illustrated how much I had in common, with my respondents, and in a way how much my life world was very much intertwined with these officers, and thus what I shared with them on a human level in terms of feelings and experiences. In these other instances, I felt an almost insurmountable distance between our subsequent life worlds, which made it very difficult and sometimes even impossible to refrain from judgment. And my way of coping with these moments actually changed over time. This is something that I really had to sort of come to terms with, because in the beginning of my field work, I would refrain from any comments, when something happened or when they really abused power, or were talking about different groups they had checked using very overtly racist slur. And I didn't say anything, but partially because I felt some of these officers were testing me by seeing if they could expose me for the quote unquote spy, whose sole aim it was in their perception, or at least in the perception of some, to cast the military and border police in an unfavorable light. But over time, and especially after spending more time around the same officers, I responded to these moments by actually asking questions. At most to help me understand what assumptions, what concerns, and what ideas were actually underpinning their actions and their comments. And it was through asking these questions that I was led down a path of deeper understanding of where some of these officers were coming from, which allowed me to, at times, climb and sometimes even overcome what sociologist Hochschild calls the bridge of empathy. that was standing in between us, or that was bridging the gap between us. And it was in these moments that I actually felt a little bit hopeful, not because empathizing meant that I was able to justify the actions of these officers that I had observed, but because in a world that is increasingly polarized, especially when it comes to themes such as migration, borders, and national security, I was able to at least connect with somebody whose opinion and whose actions I didn't share or condone, and have somewhat of a meaningful exchange. Exchanges that would sometimes, not all the times, lead to self-reflection on the part of my respondents, and reflections on their personal agency, reflections on the impact of their decisions, as well as reflecting on how the organization that they worked for and worked in actually contribute to a change, or how a change in their perspective of what the world looked like or should look like. And I think it is in these moments that I felt that little bird of hope, because through reflection maybe change can arise. And so the adoption of what in the anthropology of the state literature is known as a non-judgmental frame allowed me to put the actions of individual border officials in the broader context of the larger state agency in perspective, by acknowledging that responsibility for what happens in the world can only very rarely be attributed to a single individual or a small group of individuals who are deliberately controlling those outcomes. And this comes back to the necessity to not see the state as this monolithic block, but instead to acknowledge the fact that any form of control, whether it's crime control, migration control, border control, or a combination of all three, is exercised through a range of complex actions, interactions, and inactions between groups of individuals, state and non-state actors, guided by a plurality of both formal and informal rules and regulations. Over the years, I also have come to learn that the mere choice of conducting research among state agents that are partaking in and maintaining an oppressive and exclusionary system that causes grave harm to people on the move can result in words of caution, and sometimes perhaps even sentiments of suspicion by fellow academics. Although this is to a certain extent understandable, it is important to stress that researching the practices of state agents and agencies by deeply engaging with them through ethnographic research while adopting this non-judgmental framework can be done in a way that is still very critical, as adopting such a framework and climbing the wall of empathy only applies to our individual respondents in a particular moment. It does by no means entail a suspension of normativity itself. It is thus perfectly possible to retain a caring and non-judgmental attitude towards one's respondents and empathize with them while still normatively rejecting and perhaps even attempting to combat the particular social system or events that they are connected with or represent. As Hochschild, while talking about her own journey as a researcher while conducting her fieldwork that would lead to the book Strangers in Their Own Country, observes, and I quote, "We wrongly imagine that empathy with the other side brings an end to clear-headed analysis, when in truth, it's on the other side of that bridge that the most important analysis can begin." I want to stress this today, obviously not to justify my own research choices, I fully stand behind those, but to ensure that future generations and junior scholars also feel the freedom and the space and are aware of the necessity to dive deeply into the state and its agents through ethnographic fieldwork. We can talk about difficulties in getting access to these agencies, of course, because that's a big issue. We need that work to be done, and we need to understand how bureaucracies operate and how processes of state coercion and repression are being produced and maintained while paying attention to the different norms that are involved. Before we can overturn the dynamics of crimmigration, to bring it back to the main focus of this talk, We need to understand the roots of the apparatus. We need to understand the politics, and we need to identify the crimmigrators, and know to what extent they actually feel the need and space to resist the system in which they are finding themselves. If so, we can perhaps find allies in unforeseen but very powerful places. What my activism has brought me so far, one might ask, as I'm very aware of the fact that this all might sound rather naive and rather abstract, and I'm not going to talk about what I would consider successes in order to sound as I think very highly of myself, but more from a perspective of managing expectations when you are hopeful and you want to actually bring about change. So while working on my book, I traced back the first discussions that I had with the Dutch military and border police to negotiate research access. And it was very interesting to see and also to remember what a process that has been, and how much of what Schwell calls navigating difficult terrain I had to do, and I continue to do this morning even. I'm more than happy to elaborate more on that part, as I said, of my research, because I think it is also very important that we talk and that we write about these arrival stories. How do we end up actually in a field? Because there's often not a lot of room in articles to talk about that, and it's sometimes presented as if that part of doing research is detached from the research itself, whereas I think in those moments a lot of important decisions are actually being made. But over the course of the years, I've been the only researcher that has had the access that I have within the organization, and especially in monitoring on an operational level, so on the ground, these bordering practices. And as a result of my research and the fact that it was published also in Dutch with a different audience than an academic audience in mind, the NGOs that I referred to earlier were actually able to use it to build their case against the military and border police to question their practices. But, and this is where the management of expectation part comes in, based on my research, they did not stop conducting these checks. And my research has not put an end to racial profiling in inter-Schengen borderlands. But it did start conversations about what is actually happening and how the border has vanished while at the same time it is everywhere. It started conversations about how race continues to be an operating mechanism of nation building in Europe, and how despite its anti-racial attitude, through the dynamics of so-called colorblindness, Europe has become the prevailing site of everyday racism, not just for those who recently arrived, but equally for people of color, European born and bred. And these are conversations that happens, and I'm coming to a closing, in control posts between border officials, conversations that happen on the organizational level, on the national level between policymakers, between politicians, but also on the European level. And also to come back to the importance of discretion as the ghost in the possible ghost in the crimmigration control apparatus, whereas it can also be a site for resistance, in order for state agents to use discretion as such, as a site for resistance, it is of vital importance that one is aware of this and that people have the tools to actually act differently than from how one has been organizationally socialized, which requires being aware of having that discretion, of the process of socialization, and of being able to resist. And this is where research can help and support those working for the state to take action from within. And although my continuing working relationship with the Dutch military and border police is still a struggle at times, and I'm still, as I said, even this morning, finding myself navigating difficult terrain, that especially has to do with continuously having to manage expectations also on their part, and continuous learning on my part of cultural patterns, power dynamic, and especially very specific things that are very specific to a military organization. Doing that navigation and doing that hard work is really worth having access and gaining insight into a world that otherwise largely remains hidden. Because uncovering these hidden but powerful sites for state coercion and writing about them for broader audiences of practitioners, policymakers, NGOs, and the general public is the form of public and activist criminology that fits me. And so I come to my real closing. During the same annual meeting of the American Society for Criminology, where Belknap gave her presidential address, human rights activist and law professor Brian Stevenson was asked to talk about the success of his work with the Equal Justice Initiative that litigates on behalf of condemned prisoners, juvenile offenders, people wrongly convicted or charged, poor people denied effective representation, and others whose trials are marked by racial bias or prosecutorial misconduct. In his talk, Stevenson identified 4 critical components for success in scholars' effort to work towards social and legal justice. There are proximity. People need to have proximity to their study objects, providing narratives about crime that are not driven by fear and anger, protecting one's hopefulness so that we believe change can happen and we can be part of this change, and recognizing that making choices to advocate for justice and fairness often necessitate our own uncomfortableness in the process. And I think these, or I want to echo like these criteria or these things to keep in mind when you're doing that work in the context of studying migration and border control as well, right? It is on us to remain close to all the actors involved in or captured by the immigration apparatus, and also to those that make us actually feel really uncomfortable because we don't recognize where they're coming from. We have the responsibility to counter these very dominant and ever more dominant narratives about immigration by practicing a more public criminology. So right beyond the audience of fellow academics, as important as that, of course, is also. But also we need to remain hopeful. And through today's talk, I hope that I have been able to underline the urgency for criminologists and legal scholars, that it is important to work together if we want to have an impact in not just the area of immigration and border control, but I think in many of these concerning areas and topics that we find ourselves studying. And although in the light of the current state of the world, it might be difficult to remain hopeful about a great many things, not in the latter, the development of migration and border regimes and the impact of those regimes on the lives of people on the move, it is precisely now that it is crucial to not lose hope, as it is only by protecting that little thing with feathers that we can trigger and be part of change. And looking again at the Border Criminologies Network and the fact that so many scholars are voluntarily dedicating time and effort to ensuring that that network does what it does best, it gives me hope and makes me hopeful that through these international and interdisciplinary collaborations, we can make enough ripples, because that's the management of expectations, be happy with a ripple, but eventually, hopefully, we can make enough ripples that will lead to a turning of the tides. Thank you.